Hello guys, welcome to our channel Random Dictation. Subscribe our channel for more dictations on daily basis.
Shri S. K. Mehta, Learned Counsel for the Society, contends that, in this case, both the parties had taken up inconsistent stands at different stages of the litigation, and in that state of affairs, the courts below should have ignored the past conduct of both the parties and gone by the contents of the documents of title in order to decide the matter. Stop. The courts have held the conduct of the society in some of the prior litigation, but when it came to a consideration of the like conduct on the part of the plaintiff, they have chosen to make light of it, accepting the lame excuses put forward on his behalf. Stop. We shall therefore consider the impact, if any, of the earlier proceedings in this case on the question of issue. Stop para. The detailed narration of facts set out earlier will show that the parties have not been consistent in their stance and have tried to blow hot or cold as the occasion suited them. Stop. Taking up the stand of the society. First, the society in its application to the custodian for reduction of rent claimed successfully that what was allotted to it was only a plot of land and that the small shed thereon had been put up by the society itself. Stop. So also in its application for allotment dated 21 1957 and 1510 1960, it returned to the property only as an industrial plot. Stop. The letters addressed by the society to the custodian and settlement commissioner, as well as the application for reduction of rent and the order thereon, are valuable pieces of evidence, both because they are anterior to the litigation between these two parties and also because they reflect the representations of the society and the findings of the very authority that allotted the property to the society. Stop. The society represented that it had been allotted only a plot of land and that the shed had been put up thereon by itself, and this plea would not have been accepted by the custodian. Stop para. Shri Mehta tried to argue that the custodian has only reduced the rent on general grounds and has given no finding that only a plot had been allotted to the society, but we are unable to accept this contention, as both in the opening sentences as well as in the body of order there is a clear finding to this effect. Stop. This is a very serious strong circumstance to show that what was allotted to the society was only a plot of land. Stop. Secondly, the findings of the rent controller in the application under section 44 filed by the society. Stop. Right or wrong, have attained finality as between the parties, and it is not open to the society on principles analogous to res judicata to take a contrary stand in these proceedings. Stop. It is true that in the suit for injunction filed in 1964, as well as in its application under Section 44 of the Rent Control Act, the society took up a contrary position and claimed that the property was tenanted premises. Stop.